Yeah, let's take a look at Stebbins v. Polano and see what's happened since we last left Mr. Acerthorn. So here's Stebbins v. Polano, the OG accidental live stream case. And we see at the end here, the judge grants the motion to intervene, denies default judgment, dismisses the action. We already went over all this. Then there's a request for miscellaneous relief and leave to file a document and a request for reconsideration. So that seems to have come from Mr. Stebbins in between the judge granting the motion to intervene and then issuing a judgment. And then there's an order from the United States Court of Appeals. And then in the Stebbins v. Rabolo case, sort of the companion case or related case to this one, the judge lifts the stay, screens the complaint under the informal pauperis rules, and dismisses the case. Then Stebbins files another motion for reconsideration, or maybe the same, we'll see. And then the judge enters judgment. And then Mr. Stebbins files a complaint on, I guess that was July 11th, and then here's a new complaint on July 11th, Stebbins v. Commander ImperialSalt, which is completely different. It's not the accidental live stream case. Now it is some kind of collaboration or work for hire case, which we have to evaluate completely differently. So let's start looking at all of this together and see what we see. So we'll start with Mr. Stebbins' motion for reconsideration in the Polano case. He says the court stated I cited no legal authority showing that a motion to intervene cannot be used to circumscribe a voluntary dismissal. And now he's asking for leave to talk about Dukes v. Walmart stores. The court lacks jurisdiction to adjudicate a proposed intervener's motion to intervene. We'd have to look at that case. It's a district court case, and we'd have to see what specifically was that motion to intervene denied. Hey everyone, it's me, Leonard French, the editor. I thought I would look up this citation to the Dukes versus Walmart stores case. And after some searching, I did find the specific document, document 1167, and it does indeed have the quote at the end that Mr. Acerthorn quotes, "Because the court lacks jurisdiction to adjudicate the motion to intervene, it need not consider whether the proposed interveners satisfy other requirements." When we're citing case law, context will matter, and the judge will want to analyze what the context of that case was, and does it really apply? Because, for example, in this case, this was 15 years of litigation that ended with a voluntary dismissal of all parties. This was a voluntary dismissal of the action, which included a stipulation of dismissal signed by all parties who have appeared. And that mooted the case or controversy requirement, preventing the court from adjudicating a proposed intervention. Similar to the case here, with the distinction that makes the difference being that Acerthorn maintained a case and didn't dismiss everybody from the case. If he had dismissed everybody, then I think Dukes v. Walmart stores may apply. In another case, a motion to intervene was pending when an automatic dismissal was filed, and the motion to intervene should not affect the plaintiff's right to dismiss. So I think that was in the opposite order. He says, therefore, leave to file a motion to reconsider should be granted so I can provide the legal authority the court says I lack. Sometimes courts will allow you to have a second bite at the apple, but sometimes they won't. If you didn't include it the first time, that can be enough for a judge to say, there's no way you're going to overcome the problems in this case. Second, he says the court has admitted that it is dismissing the case to punish me for abusive behavior. And then he quotes the courts saying plaintiff's behavior in this case favors permissive intervention. Plaintiff has made no secret that he dismissed the corporate defendants to prevent them from challenging the live stream's copyright. Stebbins goes on, I have tried to tell the court time and time again, this is not the reason I issued the voluntary dismissal. It was just to avoid the tedious delay in litigation. I don't know if that overcomes the related case that you filed and the lack of copyrightability of an accidental live stream. Third, I should not have been required to show any of these things. Commercial Space Management Company versus Boeing, a Ninth Circuit case from 1999, precludes any means of circumscribing the voluntary dismissal, literally the entire scope of any attorney's imagination from negative infinity to positive infinity. Somehow I don't think so. Stebbins goes on, fourth, the court finds that because I did not intend to create this live stream, none of the creative expressions contained therein count as minimally creative, even if those same things would constitute minimal creativity if done under any other circumstances. No, I think it is a violation of the requirement of fixing the expression in a tangible medium. If you come to possess an accidental live stream that you did not start, then you did not fix the expression as a work in a tangible medium. You did not record it onto the disk. Something did, but you didn't do it. Therefore, you're not the author. It does not owe its originality to you. Therefore, you don't meet the requirements of originality, one of which is also minimal creativity. I think those are just two things that are happening side by side in the judge's analysis. Fifth, the court finds that my copyright is lacking in human authorship. However, the court ignores my argument where I point out that this allegation in the complaint is not based on personal knowledge. This does not simply dampen the probative value of the allegation, it renders the allegation completely inadmissible. Okay, so he thinks that an admission by the plaintiff is not admissible. Hi, hello there, me again. So Rule 602 of the Federal Rules of Evidence is the need for witnesses to have personal knowledge of the facts that they are testifying to. A complainant is a party, is not a witness in the same sense. Now, yes, when that complainant is on the stand testifying, they should only be allowed to testify to things that they have personal knowledge of. But in your complaint, you're alleging facts and connecting those facts to a claim for relief. And the judge uses all of that, taking it in the light most favorable to the complaining party when someone files a motion to dismiss, for example. And there is no Rule 602 at the complaint stage because you don't have witnesses and testimony yet at the pleading stage. Sixth, the court finds that the registration application contained inaccurate and incomplete information, but the court ignores the evidence that I provided, which showed that the Copyright Office was indeed fully aware of this error and chose to grant registration anyway. I don't know what evidence he provided of that. I did not see that. Maybe he did. He says there is still a claim remaining. He included a claim for a 512F misrepresentation, which has not been dismissed. Okay. Just because I didn't move for summary judgment on that claim does not mean it is still pending before the court. Well, I think the court found that the accidental live stream is not copyrightable, therefore it can't be the subject of a 512F copyright misrepresentation claim. That would be my analysis there, just briefly. So the court has offered no basis for dismissing that claim. It's like fruit of the poisonous tree, or it's a domino effect. When one falls, the other has to fall. You can't maintain a copyright claim under a different part of the Copyright Act when you didn't have an underlying copyright in the first place. And then he asks the court to recuse itself from the proceeding. The court has demonstrated that it personally doesn't like me because of my voluntary dismissal, and the court plans to issue adverse ruling against me from here on out just to punish me for doing so. So I didn't get my way, therefore the court is punishing me. There might be some other more reasonable explanations in between the court hates me and I won. If the court cannot set aside its personal grudges and issue rulings with impartiality, it must recuse. My right to an impartial judge is absolute. No matter what evidence was against him, he had the right to an impartial judge. Wherefore, premises considered, whatever that means, I respectfully pray that this motion for leave to file a motion for reconsideration be granted, so requested this 11th day of July. I don't know if the judge will actually rule on that, or if the judge will just ignore it from here on out. But that wasn't the end. The judge issued the judgment. The U.S. Court of Appeals issued a denial. Petitioner has not demonstrated that this case warrants the intervention of this court, the appeals court, by means of the extraordinary remedy of mandamus or prohibition. Accordingly, the petition is denied. Petitioner's motion to proceed in for pauperis is denied as moot. No further filings will be entertained in this closed case. Denied. Most of the time, the Court of Appeals doesn't have to add that extra language that they won't entertain further filings. So they've looked at the vexatious or bulky nature of the underlying litigation and reminded Mr. Stebbins not to file anything more with the Court of Appeals in this case. So then you have the Rebolo case. This was the judge's order. So Jeffrey White dismissing Mr. Stebbins' case against Emily Rebolo. The court had put a stay on the related case. The court lifts the stay, screens the complaint according to the IFP statute. The court must dismiss an informa pauperis action if the court finds the action fails to state a claim on which relief may be granted, or that the action is frivolous or malicious. So the court then finds that that is. Plaintiff brings this complaint about the infringement of several purportedly copyrighted works. They're not copyrighted. The court dismissed with prejudice plaintiff's claims based on the live stream in the related case on the basis that the live stream lacks creativity and human authorship because the recording occurred unbeknownst to plaintiff. For this reason, the copyright infringement claims based on the live stream are dismissed with prejudice for failure to state a claim. Plaintiff also brings copyright infringement claims against several defendants based on the use of 10 2D images. The Copyright Office rejected plaintiff's request to register the images for copyright protection because they are basic geometric shapes. What is with trying to copyright basic geometric shapes? What is it? Stop it. Stop it. Based on the Copyright Office's refusal, plaintiff does not have a presumption of validity over the 2D images. Further, plaintiff's allegations fall short of establishing the copyrightability of the 2D images. As described in the complaint, the images are a blue honeycomb background comprised of hexagons, but as the Copyright Office found, there is no copyright protection for basic geometric shapes. Nevertheless, plaintiff alleges the images meet the standard for creativity because he put forth the hexagons in a honeycomb pattern with a gradient color scheme. I mean, really? What are you people doing with the hexagon? What is it with the bees and the honey and the hexagons and the insatiable lust for intellectual property protection for a six-sided polygon? For this reason, the court dismisses the copyright infringement claims based on the 10 2D images. Finally, plaintiff asserts additional copyright infringement claims based on the alleged copying of other livestream videos. Plaintiff registered these live streams with the Copyright Office. Although the registration constitutes prima facie evidence, or on its face, evidence of the validity of the copyright, the presumption of validity may be overcome by some evidence or proof to dispute or deny plaintiff's prima facie case of infringement. Section 1915, this is the screening statute for IFP cases, accords judges the unusual power to pierce the veil of the complaint's factual allegations and dismiss even those claims whose factual contentions are clearly baseless. Here, the court has sufficient evidence to dispute the presumption of validity offered by registration. In the related case, the record showed that plaintiff did not disclose the true nature of the livestream video. Although plaintiff obtained a certificate of registration, the court found this evidence rebutted the presumption of validity, and the court determined that the April 10th livestream was not copyrightable. The court finds that plaintiff's proven lack of candor in his prior application overcomes the presumption of validity afforded by registration of the other livestream videos. So a little bit of a stretch, but the judge is going to say, I don't trust you, so I'm not going to treat your copyright as valid. Even without the presumption of validity, though, plaintiff's allegations of ownership regarding the additional live streams are insufficient. Plaintiff does not allege facts that permit the court to assess whether the content is eligible for copyright protection. He does not describe the material or address how it meets any of the criteria for copyright protection, such as creativity or originality. Moreover, his allegations of copying are vague and conclusory. Accordingly, plaintiff fails to allege a viable infringement claim as to the remaining livestream videos. Although the court should freely give leave to amend when justice so requires, it is within the court's discretion, and the court is going to deny amendment based on potential for undue delay, bad faith, dilatory motive on the part of the movant, repeated failure to cure deficiencies, undue prejudice, and futility of amendment. The court finds that plaintiff has had multiple bites at the apple. There's overlap with the related case. Plaintiff has already amended the complaint in this action and sought a second amended complaint. Amendment would be futile, and that's the end of the Rebolo case. Not unsurprisingly, Mr. Stebbins files a similar motion for reconsideration. He claims to have made a slight misclassification. Okay, maybe someone needs to proofread. When registering the April 10th live stream, the 10 2D images are minimally creative, he says. I never provided copies of these works in the complaint, and the court cannot look beyond the complaint for evidence with which to base dismissing the complaint. Okay. I mean, it's a fair response to the judge washing his hands of the whole thing. You had this ancillary claim, and maybe it should have been your primary claim. Maybe it should have been a separate lawsuit. The court is denying me my constitutional right to a day in court, and is doing so based entirely on his personal grudge against me because I issued that voluntary dismissal. No, it's the judge has gotten to smell the rat, and the judge is spooked. You've spooked the judge, is I think what has happened. Not legal advice, not individualized legal advice in any way, but in my opinion, I think that Stebbins has spooked the judge. So then, Stebbins files a new complaint, just totally unrelated, on the same day. This one is against Commander ImperialSalt and Zelzander, and it has something to do with a collaborative live stream. Imagine how this world would work without the internet. Imagine if someone stole merchandise from a California retailer, then drove to Florida to distribute the stolen goods. Both Florida and California would have concurrent jurisdiction. Okay, so he's trying to understand how jurisdiction works. Okay, so plaintiff is Acerthorn, and defendant is Commander ImperialSalt and Zelzander on Kiwi Farms. Oh, great, a Kiwi Farms case. This is going to be great. I can tell already. June 2022, set the scene. Another YouTuber and I, Acerthorn, agreed to do a live stream debate together on my Twitch channel. This other YouTuber goes by the alias Vacant. I do not know his real name. He agreed in writing that he would not be a co-author of the live stream, and even if he hadn't agreed to that, he still did not participate in affixing the stream into any tangible medium of expression, which is necessary to be considered a co-author, so he knows how tangible medium expression works. We agreed to have the debate on June 25th, so on June 10th, I made a promo video. At timestamp 028, I provided a disclaimer saying that I will be seeking copyright registration, which is actually not required. As of the time of this writing, the registration is currently pending. That's going to be a problem. Don't we have, is it the wall-street.com case that says you have to have the registration or a denial of registration before you file the case? So he's filed the case. He doesn't have the copyright registration yet. He has the application. He doesn't have the granted registration. However, seeing as it was originally a live broadcast that I notified viewers of the stream 48 hours in advance, I disclaimed that I was going to seek registration, and I applied for registration within 4 days. I am not required to have registration in hand at the start of litigation as normally required. Does he want to explain how? Or he just says, I'm not required.
I have a permit. This just says I can do what I want.
Anyway, Vacant and I had the debate stream on June 25th as planned. After the debate ended, I transferred the video to my YouTube channel. I restricted viewing of that video to those who paid $1 per month or more. Were it not for this paywall, the video could be viewed at the following URL. So then, someone on June 28th, acting under the alias Commander ImperialSalt, paid my channel the $1 fee to see the stream, but rather than watch the stream, they proceeded to download the stream, and this constitutes copyright infringement, illegally downloading the video in the first instance. Okay, maybe, sure, yeah, I could see that. There's also the argument that it falls under some kind of time shifting or personal copy, but yeah, that's the beginning of a copyright infringement claim, sure. This is obviously illegal under copyright law, he says, just like how it is illegal to use a torrent app to download entire movies or video games without paying for them. Furthermore, his entire purpose for committing this act of infringement was to commit infringement number 2, which was reposting the copy of the debate on Kiwi Farms at that address, which Mr. Stebbins addresses criticism and commentary. I'm assuming that's because of fair use. I like how 8 minutes into it starts to devolve, etc., etc. I'm not here to be insulting. This is not nearly enough criticism or commentary for him to have fair use case, because he uploaded the entire video. I happen to agree. A short time later, he made a post admitting that he paid the fee for the sole purpose of re-uploading it. There are only 2 elements necessary to the... Okay, so he's going to start arguing copyright claims. He's going to request statutory damages. And yeah, if he registered the work properly, I'm still not sure about his filing the complaint before the registration has gone through and he's got the registration. That's going to be a problem. And of course, he has to overcome the problem of identifying Commander ImperialTycho, or whatever his name was. Commander ImperialSalt, excuse me. I'm hungry. So then the court issues kind of an automatic notice to show cause that he has to file something about copyright and related cases and things. And he files that. That's here. And then he requests an emergency motion. He really likes these emergency motions for the issuance of a subpoena duces tecum, which is a subpoena to like a third party, to YouTube in this case. He asks the clerk to grant him a subpoena to the ISP to identify Commander ImperialSalt, I'm assuming. He uses the emergency tag because he's afraid of evidence being deleted. I'm not sure if he understands how this works. YouTube may let you delete your account, but I doubt that it deletes the actual evidence of who created the account behind that. But maybe they do. Sure. So he makes the argument that it's a evidentiary issue. Meanwhile, apparently someone is trying to scrub their identity from Kiwi Farms. I don't know how that's going to work. I don't know if you can just subpoena Kiwi Farms. I mean, you can. I don't know how successful that will be. So Stebbins is saying that someone, Commander ImperialSalt or somebody else, is trying to delete their account, and it's a malicious attempt to avoid having his contact information subpoenaed. Hence an emergency motion. When reviewing Informa Pauperis petition, the court is allowed to screen, etc. He respectfully requests that his IFP application be expedited, etc. Okay, so amazingly enough, this sounds more like an actual copyright claim. Someone clearly, at least on these facts, again, reading the facts in the light most favorable to the complainant, to the plaintiff, which is not appropriate to do for judgment, but is appropriate to do when someone makes a complaint. So assuming that the facts are what he says they are, someone paid to get access to his live stream, then downloaded it, and then re-uploaded it so people could make fun of him on Kiwi Farms or whatever they're going to do with that there. Yeah, that's closer to a claim of copyright infringement. Is it a fair use because they're using it to mock him? Probably not. Not uploading it in its entirety. We saw with the we thought she would win case, the Carl Benjamin versus Aquila Hughes, or Aquila Hughes versus Carl Benjamin case. We saw that there needed to be an edit. There needed to be something more, something transformative. Just reposting it and saying this guy's whatever is not going to be enough, I don't think, for anything to be labeled a fair use or to overcome Mr. Stebbins' complaint. So this is actually a pretty good complaint. We'll see if it's worth pursuing, but Mr. Stebbins seems to have a history of pursuing these things. Good, I guess. Give him something to do, go after an actual seemingly meritorious case. Kiwi Farms is known for doxing, mocking, dogpiling. Yes, we've experienced Kiwi Farms before with the Alex Mauer and Imagos Softworks case. That was a fun one. Anyway, yes, that I think is all I've got to show you in the various Acerthorn litigations, happenings, lawsuits. Let me know what you think of those in the comments below. Thanks for watching. Special thanks to my top supporters in the month of July: John Steele, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, ShadowTycho, Gutbrodj, PureMagma, Eric Tams, TechTechPotato, The Blood-Soaked Survivors, Wyatt Calandro, and King Aries. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for my weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all.